programs to help navigate their losses for the families. These policies reflect the ministry's dedication to honoring the sacrifices made by our soldiers and the families. As I conclude, I want to state that on behalf of the leadership of KDF, and I can confidently say on behalf of the Chief of the Kenya Defense Forces, that we are committed to ensuring enhanced capacity for our forces, to ensure mission readiness, to ensure a strong posturing, and to ensure that we have a solid welfare support system for our veterans and all our forces. I am very committed to support the ingenious demonstration across the forces of the capabilities of our forces to contribute not only to enhanced capabilities within KDF, but also a wider spectrum of defense industry that I know is going to take our country to the next level, even in terms of contributing to our GDP. I want to congratulate the awardees, despite the Attorney General having almost, at least we didn't give her the microphone, because she could have declared our award ceremony unconstitutional. So we have time to salvage CDF, but allow me to say that we congratulate all the awardees of today and the entire KDF fraternity for your zeal and commitment in service to our nation, and as has been demonstrated by our young people here, Kenya and KDF in particular is known for its professionalism, ingenious innovation, although Professor Hamo alikuwa anatuchongoa hapo kidogo, saying that, you know, tumepaka rangi nusu, but that is the essence of innovation, Professor Hamo. And thank you for the entertainment na kutuchekesha. Tutaonana nyuma ya tent ndio tuweze kuona yale matakwa yako, how to progress them. And for our young people, thank you for the entertainment. Our little brother, Sami Brayo, you are the essence of inspiration. And that's the spirit of Kenya, of resilience, of pressing forward. And as I said, despite the difficult and tumultuous moment that we find ourselves in globally, not just Kenya, particularly economically, I can categorically state that as the KDF family, we are going to commit and strengthen our resolve even more. And I can commit as a CS that we will leave no opportunity unturned to make sure full support for KDF in all the needs that there are. Asanteni sana. Mungu awabariki. And I can say that on behalf of the Kenyan government and the great people of Kenya, we salute you, KDF, for all your unwavering service. tunawaenzi sana. And I can say that as your cabinet secretary. I wish you all a happy KDF Day. God bless you all, and God bless Kenya. Asanteni.
Tumpongeze waziri wetu kwa makofi mazuri. Asante sana waziri wetu wa ulinzi. Tumefika kipindi cha sherehe za machweo ya jua, beating of the retreat by the KDF band, na niombe kwa heshima Senior Meja, iwapo mko tayari, upande wa pili afisa mteule daraja la kwanza Mary, beating of the retreat by the KDF band. Nizamu ya mkurugenzi wa muziki, nizamu ya mkurugenzi wa muziki kutekeleza wajibu wake alasiri ya leo. Kwa heshima naomba kwa wimbo wa Injili, kwa wimbo wa kushusha bendera na wimbo wetu wa taifa. Hivi sasa mwelekezi mkuu wa bendi za majeshi ya ulinzi akija kumwomba mgeni wetu rasmi idhini ya kuondoa bendi hizi uwanjani. Asanteni, kwa heshima tunaweza kuketi tafadhali. Anaondoka hivi sasa uwanjani mkurugenzi wa muziki jeshi la nchi kavu baada ya kutekeleza majukumu yake alasiri ya leo. Asante sana mgeni wetu rasmi kwa kuweza kupokea saluti hiyo ya heshima kutoka kwa bendi za majeshi ya ulinzi chini yake mwelekezi mkuu afisa mteule daraja la kwanza Mary Ekiru, wakiondoka hivi sasa uwanjani baada ya kutekeleza majukumu yao siku ya leo. Mgeni wetu rasmi, tunaingia katika kipindi cha picha na nitaomba sote tuweze kutulia hadi kipindi hicho kitakapokamilika, kisha nitaweza kuwajuza wakati wa kufumukana mahali hapa tukielekea kwa mankuli. Nitaweza kumpisha mwenzangu Meja Justin Pamba aendeshe kipindi hicho cha picha. Welcome sir.
Basi asante sana. Bendi yetu inapoondoka sasa, tunaingia kwenye kipindi cha picha za kumbukumbu, na ningeliuliza kwa heshima kwamba niseme itakavyokuwa. Picha ya kwanza itakuwa ni ya mgeni wetu rasmi, the CDF, the AG, the PS, the VCDF, the IG and the service commanders. Watakapopigwa picha ya kwanza, wafuatao picha exposure ya pili itakuwa ni ya retired general officers ambao watakuja kwa flank kwa picha ya tatu, na ya mwisho FSMs both serving and retired. Kwa hivyo ndivyo mambo. Tafadhali, najua DFSMs especially wale retired naona mko mbali kidogo, mwanze kujongea ili tunapoanza kipindi hicho tuweze kwenda kwa haraka kidogo. Basi wapiga picha na wanahabari tuwe tayari kabisa, ili tuchukue muda mfupi kabisa kwa wageni wetu, mgeni wetu rasmi na wakuu wengine wa kijeshi walio katika picha hiyo kuweza kwenda kwa haraka. Kumbuka kwamba nitamwomba mgeni rasmi baada ya picha hiyo ya kwanza akaweze kubaki mahali pale, alafu akuwe flanked na retired general officers katika picha ya pili. Basi afisa anayehusika na upigaji picha huo anaomba ruhusa ya kuweza kuendelea. Basi exposure ya kwanza ndio hiyo, na naomba ya kwamba DFSMs both serving and retired ndo hao wanakuja. Wazee wa kazi wale wamekwisha staafu, lakini wangali wako sawa kabisa. Basi wanapojongea karibu, picha ya pili itakuwa ni ya retired generals, retired general officers ambao ndio hao sasa mlikwisha julishwa ni akina nani wanakuja kujiunga kwa hiyo picha, wanakuja kuflank mgeni wetu rasmi na wakuu wengine mbalimbali ambao wako kwenye picha hiyo. Exposure ya pili inaendelea sasa, ni ya general officers, retired general officers. Retired general officers ndio hao wamekwisha jiunga na mgeni wetu rasmi katika exposure ya pili. Punde tu watakapomaliza exposure ya tatu itakuwa ni ya both serving and retired DFSMs. Both serving and retired DFSM. Punde tu watakapomaliza mgeni wetu rasmi ataweza kuondoka kwa wakati wake mwenyewe, na atakapokuwa anaondoka nitauliza kwa heshima tukaweze kusimama muda huo utakapofika. Na ndio hiyo picha exposure ya pili ya retired general officers wanapiga picha na mgeni wetu rasmi. Afande, asanteni sana. Thank you very much. Kwa hivi sasa picha ya tatu na ya mwisho ni ya retired and serving DFSMs ambao wanapigwa picha kwa hivi sasa, na ndio itakuwa picha ya mwisho ya kumbukumbu katika hafla hii ya siku ya leo.
cannot be fragmented into a fraction. And therefore, the logical thing to do, of course, would be to round off the decimal to the nearest round number. And the nearest round number in this case is 31. Speaker, we are here as a quasi-judicial hearing. And I see us, of course, as judges, very, very strongly so in this case. And Speaker, I also see us akin to scientists who have been given the mandate to deal with this case with precision. This is a laboratory, Mr. Speaker, and we are all scientists, and we have been called to make a very fine cut in this with these POs. Speaker, science has laws. There is the law of gravity, law of motion, the law of the Mendel's law, the Megan law, several laws, Mr. Speaker, and those are absolute. They cannot be moved. They cannot be wished away. Similarly, Speaker, the High Court has ruled through this jurisprudence that that you should calculate to the nearest round number, and that, Mr. Speaker, is law. It's through a court of law, and I think that we should continue in that way. 31 has been met in terms of votes, and therefore we should listen to this case further and listen to the substantive issues therein. Speaker, also, you have been invited by the Governor's Council to mirror the decision of your counterpart in the National Assembly. I feel that is out of order, Speaker. You are not a conveyor belt. You are not somebody who regurgitates what the Speaker of the National Assembly does or says. You are not a parrot of the National Assembly, Speaker, and therefore being invited to mirror a decision that...
Senator Seki.
Thank you, Honorable Speaker. I also stand to put my voice on this matter. Honorable Speaker, I want to believe that the County Assembly have pronounced themselves, they have presented themselves. The Governor panel has also presented themselves. And now it is the Senate now to determine whether to listen to the PO to proceed with this matter. But I want to assure and believe that this matter will be determined in whichever case, Honorable Speaker. Either we have presented ourselves, we have pronounced ourselves, we have determined ourselves before this case, or even when we determine this case when we are finishing, we listen this case towards the end. I want to believe that this is the right time, that we need to hear both sides, the County Assembly and the Governor, the Governor's team, so that at the end of it all, everything will determine, because we will see if true the County Assembly had the threshold or not, or the Governor has issues that has been accused to. It is going to be determined towards the end. So, Honorable Speaker, I believe that this is a time when we need to hear this case. We need to hear because the process has started, and there is no way we can stop this process. So, Honorable Speaker, I want to support that we proceed with the matter. Thank you very much.
Senator Akinyi Beatrice.
Honorable Speaker, I thank you for giving me the opportunity. Honorable Speaker, the issue that I want to talk to is the issue of the threshold. Honorable Speaker, you can't round off human beings. And if a threshold has to be determined, Honorable Speaker, and it has been stated, to me, Honorable Speaker, there is no way around it. We must look at the issue of threshold, and it must be determined, Honorable Speaker, because we cannot set a precedent that is otherwise. Honorable Speaker, on the PO, if it has to be determined, it is a matter that does not concern counties, and so, Honorable Speaker, I stand guided, but I think all the 67 senators stand to determine, to vote on that. Otherwise, Honorable Speaker, on the issue of threshold, Honorable Speaker, I want to support that the threshold must be met from the word go. Thank you, Honorable Speaker.
Senator Methu.
Thank you very much, Honorable Speaker. I don't want to buttress what my colleagues have said. I want to agree
that on the first PO, it was, by the way, because precedences have been said that Parliament cannot be injected on the course of its work. But Honorable Speaker, you've been invited to make a very critical decision, and without speaking on whether the threshold was 31 or 32, both parties have come with arguments and counter-arguments. Why they actually think that 31 would be the threshold, why they think that 32 would be the threshold. Authorities have been cited, especially in the Tana River case, the County Assembly, or Speaker Kaduda versus the County Assembly, on the number as to at what point you should be able to truncate the numbers, and they actually believe that it should be rounded off to the nearest whole. The defense of the governor through their counsel, Katwa Kigen, they actually feel that even at the very beginning or the inception of this county assembly, there had been set a precedence that 32 would be the number. So, Honorable Speaker, you've been invited to make this particular decision, and this is a weighty decision because if you are to allow this PO, then this impeachment proceeding will fall as at now. We shall not have, the jury will not have had an opportunity to make a decision on this particular matter. It is a very serious invitation, and I would want to dissuade you, Honorable Speaker, from allowing or agreeing to fall prey to Rule 30 of the rules of procedure, that you make this decision on the preliminary objection. Please, Honorable Speaker, allow the 47 delegations to make this decision on whether, well, it could be 67 or 47, whatever would be the case, Honorable Speaker, if it touches on the counties, Honorable Speaker, but allow senators who are the jury, who are the judges on this particular matter, to make this decision. Honorable Speaker, for you on this matter, you are an umpire. You have no dog in this fight. Yours is to just umpire. No, honorable senators, we need to make progress. I may take your seat, Professor Minority Leader and Senator Kajon. I've heard you, and nothing new seems to be coming out at this juncture. And therefore, for us to make progress, you'll allow me to use Standing Order number 1 to suspend the sitting for 15 minutes so that we resume at 3:30 for me to go consider the interventions you've made and give a way forward on how we are going to dispense with this matter. Because remember, honorable senators, if in the event that we proceed with this hearing, we have to start from the beginning. The hearing hasn't started yet. We are merely dealing with preliminary matters, and therefore time is of the essence. So kindly, honorable senators, I will proceed now to suspend the sitting for 15 minutes, and we shall resume at 3:30.
Well, the question of the 2/3, whether that is the threshold was reached or not, still remains unresolved. The Speaker of the Senate, Honorable Amason Jeffa Kingi, has suspended the sitting for 15 minutes, and the House will be resuming at 15:30, indicating that he needs to consider the deliberations before him with regards to those particular preliminaries objections. And the most important one in this case is the objection that was raised by the governor's legal team with regards to the threshold of the MCAs who supported the removal from office by impeachment of the governor.
celebrations. Today, it is being marked at Thika Garrison here in Thika, Kiambu County. And we are expecting in today's event, Defense Cabinet Secretary Soipan Tuya will lead this military fraternity in marking the 13th Kenya Defense Forces Day celebrations. Well, this is a significant event in the disciplined forces, being the Kenya Army, the Kenya Navy, and the Kenya Defense Forces. Remember, this is the first event that Tuya will be presiding over as the Cabinet Secretary for Defense. But to bring up to speed and to highlight more about this day, the KDF Day is observed annually. That is to commemorate and celebrate and the Kenya Air Force. It is a day that is observed each and every October just to celebrate these men and women in uniform who serve to safeguard and protect our country through land that is the Kenya Army, our airspace, the Kenya Air Force, and our waters that is the Kenya Navy. So we expect Cabinet Secretary Sipan Tuyam, and we have also seen the Chief of their Defense Forces, Charles Kahariri, already present at this venue, that is at Thika Garrison, to lead the men and women from these three disciplines of the Kenya Defense Forces in marking this special day, whereby it was first observed in the year 2012, following the launch of the Operation Linda Inchi in October 2011, the leadership or under the stewardship of the late President Mwai Kibaki, that President of the Republic of Kenya. And that particular operation, let me just before we go to the Operation Linda Inchi, just to brief you on this year's theme, that is the KDF Day, has been themed under the one force, mission ready, that is unity in action for national security and development. This is the theme of this year's celebration, a very important calendar in the Kenya Defense Forces. Well, we expect in these events the men and women, our soldiers in the Kenya Defense Forces, who performed what the Kenya Defense Forces say or highlight to be exceptionally well, will get different duties, will be recognized and presented with awards. This is to recognize their remarkable work. Now, just to point or to take you back to some history lessons, as I had highlighted to you before, that this day was first commemorated on 2012. This is after Operation Linda Inchi under the stewardship of the late President Mwai Kibaki. Remember this operation. Kenyan troops was deployed to Somalia. That is in collaboration with the Jubaland Security Forces, liberated the south port of Kismayo and 12 other towns in Jubaland region from the Al-Shabaab controlled areas. And in the year 2012, the Kenyan troops, that is to be specific, on February, were integrated into the African Union mission in Somalia, that is AMISOM, from the predecessors of the mission following ATMIS, following a United Nations resolution. Kenya is among the 5 ATMIS troop contributing countries alongside Burundi, Djibouti, and Ethiopia, and Uganda. And for the years, our security forces from the Kenya Defense Forces have been working day and night just to ensure that our borders are secured from the threats of Al-Shabaab. And these they have done with dedication, brilliance, just to ensure we Kenyans from all walks of life are secured within our Kenyan borders. And this day is just but a reminder of the dedication that these men and women remain steadfast to ensure that we are secure and safe. So this will be a significant event because as we mark this reminder, it marks as a reminder the return home is after the conclusion of the African Transition Mission in Somali. That is in December. So we are expecting the men and women who are sent to our neighboring country of Somali will be returning home after ensuring that order has been attained in the neighboring country and also in Kenya country and also secure. Kenya for now is secure. Get back to the event and let's get back to the event and get to listen to more sights and sounds, more sights and sounds.
Vinasomea mbalimbali za kijeshi na za kiufundi za kijeshi na Kenya Army, Kenya Air Force na Kenya Navy, Kenya Air Force na Kenya Navy, haja kwamba itaweze kubadilishwa jina, kwamba itaweze kubadilishwa jina ili kwamba itaweze kujumuisha vitatu. Basi vile vile tuliweza kupata 14 Engineers Battalion ambayo kitambo ilifahamika kama Water na vile vile tukaweza kupata 18 Engineers Battalion ambayo pia iko mahali hapa, ambayo pia vile vile iko mahali hapa, na hivyo basi ikumbuke kwamba engineers wanafahamika kwa masuala ya mbalimbali na vilipuzi mbalimbali, sehemu nyingi ambazo utakuwa ukienda kwenye vikosi vingi na lazima utakutana na si hayo tu, bado kuna masuala ya ujenzi na masuala ya ujenzi na ufundi bado utakuwa unaweza kupata mahali pale. Kwa mbali kidogo tunaona kwamba tunaweza tukaongezewa tena batalion nyingine, lakini hayo ni masuala labda kama ya leo, mwaka ujao, siku kama ya leo 24 battalion, basi hiyo tutakuwa tunaizungumzia kwa sasa. Hiyo tutakuwa tunaizungumzia kwa sasa, lakini sisi wanasapa tunaomba tuweze kuongezewa, maana tunapoongezewa vitu kama hivi, maana tunapoongezewa vitu kama hivi, basi inakuwa vizuri. Kwenye upande wa burudani naomba nimwalike mwanafunzi miti ina manufaa mengi, ikiwemo matunda, mbao na kadhalika, hadi kivuli na kadhalika, hadi kivuli. Ndege wa angani hutegemea miti ili kuweza kupata dada yetu.
Following the launch of the Operation Linda Inchi in October 2011. And this year's Kenya Defense Forces Day celebrations happening at Thika Garrison in Thika, Kiambu County is deemed One Force, Mission Ready, Unity in Action for National Security and Development. One Force, Mission Ready, Unity in Action for National Security Development. And already Cabinet Secretary in charge of the defense docket, Sepan Tuya, is already within the precincts of the Thika Garrison, set to preside over these important dates in the Kenya Defense Forces calendar. Also, the Chief of Defense Forces, Charles Kahariri, together with CS Ripantuya, are currently taking a look, going around in some of the tents that have been set up by these men and women in the military, showcasing the different equipment, the different services that they offer and use in a bid to keep the country
this, Mr. Speaker, on the issue of JKIA. The issue, there is a lot of noise within the university funding model. There is the issue of social health act, Mr. Speaker. It's because of lack of information. If consumer authority ensures, they say, Senator Kalwal, information is power. If us, in government, can get the information out there, the people who oppose the policies of government, Mr. Speaker, and I can see one representative in the House, will not have a chance to bash the government, Mr. Speaker. So the issue of consumer information, consumer protection, Mr. Speaker, we must ensure, and I was, trade associations, Mr. Speaker, we should promote trade freedom. I know there is Kenya Chamber of Commerce, Mr. Speaker. We can go to US, we go to Berlin, we go to all the country, Mr. Speaker. Let us be fair. Even as we invite investors, we must also ensure competition authority protect the local farmer, Mr. Speaker. Because I saw the other day in the sugar bill, there was the issue of industrial sugar. Mr. Speaker, if we allow today industrial sugar to come, we are exporting jobs and even revenue, Mr. Speaker. But if today we put tax to the industrial sugar, those people who want to import industrial sugar will rather open a local factory and generate employment and revenue with this country, with this kind, Mr. Speaker. Mr. Speaker, I support this motion. I want to request that we support Competition Authority of Kenya. I hope in the tenure of Mr. David Kemei, we shall see a more robust, more assertive, more responsive authority that will ensure consumer protection, that will ensure consumer information, that will ensure freedom between freedom of trade and choices of a customer are well balanced within the Kenyan Constitution, because the Kenyan Constitution provides for consumer protection on all mechanisms, Mr. Speaker. Let us pass this and allow, Mr. Speaker, and I want to thank the Committee of Finance and Budget for this wonderful job. We expect other committees will do similar. With those very many remarks, Mr. Speaker, I support this motion. I thank you.
Senator Beatrice Ogola.
Honorable Speaker, I'm a bit apprehensive to support this motion, Honorable Speaker. Not because, Honorable Speaker, I should know Mr. David Kibet Kimel. I do not know him. I do not even care to know him. And I do not even care from where he comes from, Mr. Speaker, sir. All I care about is the process of the recruitment of Mr. David Kibet Kimei, who is a nominee for appointment to the position of Director General of the Competition Authority. Honorable Speaker, it concerns me that we are recruiting, a recruitment has been done, not for any other authority, but for a competition authority, where in its rightful word, Honorable Speaker, we must see a process of a competitive process that is open to all other Kenyans. Honorable Speaker, it is not my saying. The mover of the motion was very indicative that there was only one name, Honorable Speaker. And Honorable Speaker, we all know the rightful process of recruitment, that there has to be a selection process. And if you arrive with one name, Honorable Speaker, then the question is, Who are these he was competing? I've heard the Honorable Cheregei mention a lot of competencies of Mr. David Kimei, to the extent that the Senate of Nandi says he has everything. What everything means, Honorable Speaker, I do not know. Because from the report of the Finance Committee, they talk about Mr. Kimei being a lecturer. But Honorable Speaker, there are other lecturers that he could have competed. The report talks about a finance analyst. But Honorable Speaker, that is not enough to say that is the most competent, because in this country, there are other finance analysts. It talks about Mr. Kimei having been a credit controller. Honorable Speaker, there are other people who have been credit controllers. So, Honorable Speaker, we must know from in this country where we are coming from. In this country, Honorable Speaker, in some of the sectors, jobs have been advertised with some people in mind. And Honorable Speaker, it must be indicative that I said that I do not know him, and I don't have to know him. But there must be a competitive process for a recruitment process. Honorable Speaker, I would expect that an appointment would be made for a position of the chair, because that is indicated. But for a Director General, Honorable Speaker, I must have seen a competitive process that gave other Kenyans room to compete, Mr. David Kibet Kimei. Honorable Speaker, just 2 months ago, 3 months ago, we had a scene in this country that that culminated into a breakthrough into Parliament grounds. And if we listened properly to the young people that were demonstrating in this country, there was some message they were passing to all of us. And that is why I say I could agree with the sentiments of Senator Mohamed Chute. And to encourage him, I once read a book, A Man of the People by Henry Ibsen. And I want to encourage Senator Chute that that path he took is always a path of the lonely. There are never many people in that path, and you do not have to be uncomfortable about the rest of everybody thinking that the path he took is a wrong path. Honorable Speaker, what I'm saying is that when you talk about competence, competence is relative. Who are you being compared with to arrive at that competence and to arrive at that suitability? Honorable Speaker, there are many, many Kenyans everywhere. We would like to see a situation in this country where everybody is given a chance. We want all Kenyans to be given a chance. Honorable Speaker, we want equity to all Kenyans, and that is what every other person is crying about. Honorable Speaker, in the absence of the mention of other candidates in this process, then it leaves me with the conclusion that probably a job was advertised with Mr. David Kibet Kimei at the end of it. And so to me, Honorable Speaker, that is not a fair process. Honorable Speaker, the Competition Authority is a very crucial authority. Where I come from, Honorable Speaker, we have an industry called Ndiwa Sukari Industries. And this industry of late, when I talk to our farmers in my catchment area, there's a fear, Honorable Speaker, that their sugarcane from their farms are not being harvested in good time enough, because Sukari industry seem to be dealing with the pressure or a challenge whereby, Honorable Speaker, they have so much sugar cane packed in their stores. They are not able to sell the sugar cane that they are producing from the factory. And Honorable Speaker, this brings a problem because then our farmers have sugar cane that is overgrowing in their farms. And Honorable Speaker, that is our main source in that constituency. Then that brings a problem. And that is why I'm saying, Honorable Speaker, that this authority is so crucial to us. We would like a Director General that will play equity, a Director General that will look into the plight of the farmers we have in my constituency, whose farms are overgrown with sugar, but they cannot be harvested because probably there are some sugar barons that are providing sugar where their sugar should be, Honorable Speaker. And that is why, to me, the Competition Authority is very, very important, Honorable Speaker. So, Honorable Speaker, the report that has been tabled before us, to me, is not fairly considered because I do not see the comparison that was made by any other person. So if the candidate was suitable, he was suitable against who? If there was competency, he was competent against who? We needed to see. And Honorable Speaker, this is not to say that Mr. David Kimei is not suitable, but it is to say and stress that opportunity should be given for everybody to compete against each other, and that is why we call it a recruitment, Honorable Speaker. Honorable Speaker, therefore, I'm hesitant to support this motion, and I want to put it forward that going forward, all recruitment processes must be competitive and everybody must be given a chance. And if this is done, Honorable Speaker, then we will have a country that we all admire to live in. So, Honorable Speaker, those are my points, that I do not support this motion based on the process, based on the fact that only one name was provided, and I want to state that in future, all Kenyans must be given a chance. Thank you, Mr. Speaker.
Senator Mundingi.
Asante Bwana Spika, naunga mkono kwa kuteuliwa kwa David ambaye ni Director General. Kulingana vile tunajua, kukitokea nafasi ya kazi, huwa saa ingine kamati inakaa chini inachambua makaratasi, alafu inaenda inatangaza kama kuna nafasi ya kazi, na watu wengi huwa wanaenda wanaandika makaratasi na kupeana ile mambo imepeana pale kwa ile kazi. Ningeunga mkono kwa sababu kulingana vile hii mambo iko, kulingana vile nisikia senta mwingine akisema ilikuwa imetangazwa safari ya kwanza na pia ikatangazwa safari ya pili, na ndipo hapo wale waliandika makaratasi ikaenda ikakaliwa chini, na wale walichambua makaratasi wakaona David anafaa kuwa ambaye ndio general ambaye wakufanya hii kazi. Kulingana na makaratasi ya David tumeona ile shule ameenda akasomea university, hata akaenda DC na mbali mingi, hata USA. Kwa hivyo ni kumaanisha kwa hiyo kipindi amekuwa akisoma, ilikuwa walichambua makaratasi, Bwana Spika, wakaangalia amesoma vizuri. Tukiangalia kwa kazi kwa miaka 30 ambaye alikuwa na mtendaji wa kazi, tumesikia akiwa alikuwa director ambaye ni wa Kenya Lee, amefanya kazi huko na kama makaratasi yake mzuri, alifanya kazi nzuri. Tumesikia hata wengine center ambaye Ashoti alisema walikuwa wafanya kazi pamoja, na pia tukasikia hata alikuwa pia Egerton University alikuwa akifanya kazi huko Kaparaka, na pia hata Kenyatta University, na pia watu waliangalia hata mahali ingine kama upande ya Sure School of Monetary Studies, hiyo yote amefanya. Pia hata kuna mahali ameguziwa alikuwa anafanya kazi kwa Energy Regulatory Commission ambaye najua ilikuwa na kufanya kazi kulingana, hiyo department ilikuwa inaangalia mambo ya Kenya Power, mambo ya KenGen na pia hata mambo ya Hoiro, na ninajua mimi nikiwa nafanya kazi kwa KenGen pia nilikuwa sikia jina yake na aliweza kulainisha upande wa energy. Kwa hivyo naunga mkono kuteuliwa kwake kwa sababu amefanya kazi miaka mingi ambaye ako na ujuzi. Pia tumesikia Bwana Spika alifanya hata kwa insurance, merchant insurance pia kawa kazi yake ilikuwa mzuri. Kwa hiyo Bwana Spika, ningeunga mkono kwa sababu angekuwa ameanza kazi mapema kwa hii kipindi ya serikali ya muungano. Bwana Spika, mambo mingi imeharibika, ienda ikawa angelainisha, kwa sababu najua wakati alitoka kwa energy ndipo hapo miaka ingine iliyopita, Bwana Spika, tulisikia Kenya Power ile kazi ilifanya, ilinua transformers zingine asikuwa anafanya kazi vizuri, na ikawa kwa sababu hakuna competition ya kampuni ambayo ya kusambaza stima isipokuwa ni Kenya Power, kungekuwa na zingine labda angetupa ujuzi wa kuwa kuko na competition ya stima ya Kenya Power. Pia Bwana Spika, mambo mingi ile tunataka ifanyike, tunasikia kama tunataka kama ni mambo ya agriculture, vitu nyingi, dawa ya kupiga dawa, kama vitu kama Embu County kuna kitu inaitwa Mirasto Kumogoka, iende ikawa angekuwa ameangalia dawa ambaye inaweza kutusaidia ndio ile mirai yetu na Mogoka iweze ukanja ile inafaa vizuri na iwe mzuri, ndio watu wasiwe wanagonjeka. Pia mimi naunga mkono kwa sababu department nyingi angekuwa amesiangalia. Kwa hiyo Bwana Spika, naunga kuteuliwa kwa David aweze kutufanyia kazi na kuwe na ataangalia kuwe na competition kwa kila department, ndio kila mtu aweze kufanya kazi kulingana vile inafaa. Pia angekuwako akianza kazi iende ikawa atakuja na ujuzi, ingawa ako na miaka mingi ambayo iko pale mbele, anaweza kuwa atatupatia ujuzi vijana wetu huko nje na kila kona zote, ataweza kututafutia kazi na watakuwa anafanya kazi kulingana ile inafaa kulingana na ujuzi wake. Kwa hivyo naunga mkono serikali ambaye ni ya muungano, tumsapoti na maseneta wote ndio tuweze kuona tutufanyia kazi namna gani. Lakini Bwana Spika, ile kitu napinga ni mtu ambaye ndio kila mtu akisema, wengine wasema iende ikawa wangeletwa majina watatu maili. Kazi yetu ni ile jina moja tu ambaye ni Antiven tumeletwa hapa. Hiyo ndio kazi yetu ya kuchambua makaratasi yote na kila kitu yote hapa, ndio dakika ya mwisho tumpitishe ndio aweze kufanya kazi. Kwa hiyo Bwana Spika, mimi naunga mkono. Ile nakataa naye ni wale watu wanasimama wakisema huyu ni akaunti hii, ni akaunti hii, ni kama watu wengine wanataka kutufunza, wanataka kulete sijui, wengine wanasema ni wa mlima, wengine sijui watasema sasa kwao itakuwa namna gani. Kwa hiyo Bwana Spika, ningepinga maseneta wale wanakuja kuongea mambo ambaye haieleweki katika seneti hii. Kwa hivyo Bwana Spika, mimi naunga mkono. Asante Bwana Spika.
Thank you. Senator Erick Okongo.
Mr. Speaker, we have had a very interesting afternoon, Mr. Speaker, from the diverse comments that we have had from senators who have spoken on this matter. Mr. Speaker, I'm speaking as somebody who has personally gone through an experience of what it means to be profiled when seeking public office. I had Senator Ososi give a chronology that when Kenyans were given an opportunity to apply for these positions, the first list was rejected because maybe there was a candidate that the government had in mind. Mr. Speaker, in 2013, around 2011, I applied to be the chair of EACC. Our names were sent to the panel that was meant to interview us. Madam Speaker, when the panel sat, they made a conclusion that probably if we leave the names to go the way they are, the strongest candidates will most likely be Senator Omogeni. And the government suo motu cancelled the advert. They looked for a particular candidate, put a second advert, and that candidate that the government had in mind made it to the short list of 3 names that went to the president. Madam, Mr. Speaker, even though I was number 1 on the interview, the government was so determined that my name was overlooked and the person who was number 2 was given that chance. And I was left out, Mr. Speaker. So when we hear issues being raised, Senator of Embu, about other Kenyans who have been denied an opportunity, it touches me at a personal level because I know how one feels. If you come out and you expect fairness from the appointment process, but you find that because you don't have the right connections, you are left out. My contribution before this afternoon is that, Mr. Speaker, we should give equal opportunity to a Kenyan who has the requisite experience and who has expressed interest to serve in the public service or in any parastatal. It is not, Mr. Speaker, about us trying to profile anybody. If the unfairness was to an Embu, Mr. Speaker, I'll have the same sentiments. If the discrimination is on Amkamba, Mr. Speaker, I'll have the same sentiments. If it's from somebody from Coast, Senator Faki's county, I'll take the same stand. If it's from your county, Mr. Speaker, from Garissa, I'll take the same stand, Mr. Speaker, because there are many Kenyans who cannot drop names so that they get jobs. The only weapon they have is good education, integrity, and good experience. And that should be our standard, Mr. Speaker, in this House. Whether you are from the Kalenjin nation, if you qualify, that is okay. But this idea of us being told that probably in this particular position, there could have been some underhand dealings, Mr. Speaker, we should always, as a House, if that comes to our attention, we should always question, Mr. Speaker. Number two, Mr. Speaker, I know that the adverts, the long list that was published by PSC, Public Service Commission, not PSC to mean Parliamentary Service Commission, and the short list and the final interview. You know, in the spirit of transparency, I want to join what the previous senator said. In the spirit of transparency, I've looked at the report. I don't know whether there were some annexures that were excluded, but I looked at the report, Mr. Speaker. I've not seen an annexure of the long list. The long list, Mr. Speaker, should tell us all the names of Kenyans who applied. The short list, Mr. Speaker, should show us the people who made it to the short list and the criteria that was used. We'll be able to see whether the criteria was only academic or we also took into account regional balance, Mr. Speaker. We also need to see whether there was affirmative action that was taken to give opportunity to the youth, maybe to give opportunity to people with disability, or to give opportunity to people who come from marginalized areas. That's why we are senators, to ensure that there is fairness in a process like what we are trying to approve this afternoon. So, Mr. Speaker, there is nothing wrong in us seeking more transparency, more accountability from Public Service Commission. Why, Mr. Speaker, should PSC fail to give us a list? Also, we need to see from the commissioners within the Public Service Commission, how are they scoring candidates? Because the only way you can bring in an accusation of nepotism or a tribalism is to see, Mr. Speaker, how the commissioners are scoring each candidate, Mr. Speaker. So we must, Mr. Speaker, live true to the spirit of Article 73, sub-Article 3 of the Constitution of Kenya. And Mr. Speaker, if you read Article 73, it says that anybody that is seeking an appointive office should get it on the basis of objectivity and impartiality in decision making by the person making that decision. It should be free and not be influenced by nepotism or favorism. Mr. Speaker. And the people who should ensure that the Constitution of Kenya is followed and that the law is followed is us senators, Mr. Speaker. So we need, I don't know whether the best recommendation to make, Senator Mundigi, is maybe to amend our standing orders so that next time we get a name being forwarded to us, because in this particular case, the law is only giving PSC an obligation to forward one name to Parliament. We demand that they give us a detailed report, including the score chart. We see how they picked the candidate. 3, Mr. Speaker, we are a country of, I believe now 45 tribes. We used to be 42, around there. 40? Around 47 tribes.
Of the processes that are followed in the procedure for removal or proposed removal from office of a governor. And those charges were read to him. And we also had opening statements on behalf of the county assembly. On the part of the governor, who was represented by his legal team, there was the presentation of new documents that the senators did not have or had not been presented with, and they were furnished with those documents. There was an issue that was raised, that was an objection that was raised, that even as the House is sitting this afternoon, as it is reconvening for the continuation of these proceedings, the Speaker will have to give guidance on the procedure for consideration and determination of any preliminary objections that were raised. In this case, you will remember that there was the issue of the 2/3 from the county assembly, with the legal team from the governor indicating that the county assembly has a total of 47 members of county assembly, 30 elected and 17 nominated. And during the impeachment process that took place at the county assembly, that perhaps the threshold may have not been reached, owing to the fact that the 2/3 had a fraction, making the number 31.3. And that was an issue that the Speaker is expected to give guidance on. That is the Speaker of the Senate, Honorable Amason Jeffa Kingi, already making his way into the chambers. Allow me to hand you over to this live broadcast that is brought to you by the Parliamentary Broadcasting Unit in partnership with KBC. Good afternoon.
Na tuombe. Ewe Mwenyezi Mungu, twakusihi ututazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Twakuomba utuwajalie tuyatende na kufikia mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Clerk, do we have quorum? All right, proceed to call the first order, please.
Order number 1, communication from the chair. Order number 2, hearing and determination on the proposed removal from office by impeachment of Honorable Dr. Erick Mutai, the Governor of Kericho County.
Now, honorable senators, will proceed with the interventions on the preliminary objections that have been raised by the parties Senator Professor Tom Ojenda.
Mr. Speaker, I wish to address a few issues on the preliminary objection that has been raised before this House this morning. Mr. Speaker, there are two issues. The twin issues, one, Mr. Speaker, touch on the propriety of these proceedings and whether or not the proceedings before the Assembly, Mr. Speaker, under Article 181 and Section 33 of the County Government Act, my Lord, Mr. Speaker, are a continuum. In law, Mr. Speaker, the process that defines the commencement of impeachment proceedings, Mr. Speaker, and it is instructive to note, has now been settled in terms of what constitutes a process. And Mr. Speaker, the Majority Leader, Senator Aaron Cheriot, has referred to two decisions that have informed prior impeachments in this House, the impeachment of Ferdinand Waititu and the impeachment of the then Governor of Nairobi, Mike Sonko. Both, Mr. Speaker, were my clients at some point. I've therefore had the advantage of litigating on impeachment. But Mr. Speaker, I will proceed to the first objection. Mr. Speaker, the proceedings of this House are cushioned from any other processes. And Mr. Speaker—
Order, Senator Tabitha.
The proceedings of this House are cushioned from any other processes. When this court sits to hear impeachment proceedings, we sit as a court. And Mr. Speaker, because all the issues will be canvassed here, what was raised by the counsel for the governor as preliminary objections do not strictly in law qualify as preliminary objections, because the House has been asked to look at various exhibits and to see various videos. That is the province of evidence, Mr. Speaker. On that account alone, the preliminary objections will collapse because there are two interpretations of the whole number in the Nkadude case, Mr. Speaker, and in other decisions. This Senate would have to sit and consider all the submissions from parties to arrive at a proper finding as a jury at the end of this process and when witnesses are called. The magical number, Mr. Speaker, 31 and 32, 31.3, that the whip Kalwale was referring to as res ipsa loquitur, Mr. Speaker, is not quite res ipsa loquitur. The facts are not obvious because the interpretation and the tilting of all numbers between 31 and 32 are matters of evidence and presentation before this House. And that we have seen from the submissions by the County Assembly and from the other side. Mr. Speaker, I've had the advantage, and I must say this, of litigating the question of continuum in the Wambora case, the case of Marete, Kauma, and Honorable Nyaga Wambora, which was civil Supreme Court petition number 32 of 2014, where the court, in summary, in dealing with Hassan Joe, Said Shabal, and other decisions, my Lord, Raila Odinga, and in citing the National Assembly Privileges and Immunities Act, Section 12, my Lord, Mr. Speaker, insulate this House from any contempt proceedings, number one. But number two, Mr. Speaker, it also insulates this House and other institutions from any claim of interference by other institutions. The Supreme Court, Mr. Speaker, in that matter, defining the independence of institutions as a primacy that must be considered, and the Supreme Court holding our petition in 2014 on the basis, Mr. Speaker, that this House cannot be injuncted by a court. The orders issued by Judge Sergon
in regard to the impeachment of the petitioner, Governor Kericho County Government. Council therefore urged the Senate to find that in light of the court order, the matter should not proceed before the Senate. On this matter, counsel for the County Assembly indicated that the County Assembly objected to this preliminary issue, stating that the matter did not fit within the definition of a preliminary objection, that it was not a pure question of law, but rather a question of fact. Counsel stated that the County Assembly, in its replying affidavit, had provided evidence and would be making submissions to the effect that no such court orders existed. The third preliminary issue related to the matter of whether two-thirds threshold required under Section 33 of the County Governments Act, Cap 265 of the laws of Kenya, and the Kericho County standing orders were met. It was the submission of the council for the governor that the threshold had not been made, as 31 rather than 32 senators voted in favor of the motion for the proposed removal from office by impeachment, had not met as 31 rather than 32 MCAs voted in favor of the motion for the proposed removal from office by impeachment of the governor of Kericho County. Council therefore asked that on this basis alone, the impeachment proceedings will not proceed. Council for the County Assembly took a different view on this matter. First, urging that this was not a matter that could be disposed of as a preliminary matter, and that the County Assembly intended to adduce evidence to prove its case on this particular matter. Council therefore urged that it was necessary, therefore, that this matter to be canvassed within the context of the hearing so that the evidence would be presented and tested in cross-examination. A number of senators spoke to these matters in the morning sitting and in this afternoon sitting. Now, honorable senators, ladies and gentlemen, arising from the preliminary issues and having dispensed with those relating to the submission of documentation, the following are the issues that require determination and further guidance. Number one, whether in light of the court order, if any, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County. Two, whether as contended by the governor, the threshold of two-thirds required at the County Assembly was not met. And three, whether the request by the County Assembly for arrangements to be made to secure the anonymity of one of the witnesses who will be testifying for the County Assembly should be allowed. Now, honorable senators, ladies and gentlemen, it is noteworthy that only two of these three issues need to be determined in the first instance, namely whether in light of the court order, if any, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, and secondly, whether as contended by the governor, the threshold of two-thirds required at the County Assembly was not met. The third issue on whether the request by the County Assembly for arrangement to be made to secure the anonymity of one of the witnesses who will be testifying for the County Assembly should not be allowed will depend on the outcome of the first two questions. In respect of the first issue, which is whether in light of the court order, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, the Senate has been faced with similar circumstances in the past. On each occasion, the Senate has had to carefully consider two competing constitutional imperatives that arise. On the one hand, Article 2 of the Constitution provides for the supremacy of the Constitution and for the obligation of all persons and all state organs to abide by the Constitution. On the other hand, Article 1 of the Constitution provides that all sovereign power belongs to the people, and this sovereign power is delegated to the various state organs at both national and county level of government. In accordance with the doctrine of separation of powers, each of these organs is required to perform their functions in accordance with the Constitution while observing the principles of comity and respect for jurisdiction as between state organs. In the words of the former Speaker of the National Assembly, the Honorable Kenneth Marende, while delivering a communication in the National Assembly on the 3rd of September 2009, had this to say, and I quote, "Power thus divided presents the absolutism of the executive, the possible anarchy of parliament on the presumption of the judiciary, the operation of the principle of separation of powers, both separates the blends powers so that each branch serves as a check and balance on the powers of the other. It ensures the protection of the rule of law and secures the fundamental rights of an individual. The principle of separation of powers has a superficial simplicity, but is in reality inherently complex. In a communication delivered on the 23rd of October 2019, the then Deputy Speaker of the Senate, Senator Professor Kithure Kindiki, had occasion to consider this matter. The matter arose in the context of the proposed removal from office by impeachment of the then governor of Taita Taveta County. The senator for Taita Taveta County, then Senator Maruma, rose on a point of order and sought the directions of the Deputy Speaker on whether it was in order for the Senate to continue deliberating on the motion and taking further action where there was active proceedings in the matter. In the course of communication, the Deputy Speaker explained why an injunction of Parliament was untenable. The Deputy Speaker stated as follows, and I quote, "Firstly, an injunction by the court against Parliament is a frontal and deadly attack on the substance and hallowed legal doctrine of separation of powers, the bedrock of our Constitution. Separation of powers creates separate and distinct arms of government with equal but different powers. Each arm must exercise its powers in a fine balancing act to ensure that it carries out its functions without infringing on the powers of another branch of government. Secondly, curtailing Parliament's constitutional responsibilities undermines the sui generis nature of Parliament. Members of Parliament are direct representatives of the people, and thus Parliament cannot be prevented from giving a voice to the will of the people of Kenya. There are checks and balances within the separation of powers, such that while Parliament should fulfill its responsibilities unabated, the courts will have their say in the exercise of judicial authority to declare any legislation or other output of Parliament illegal, unlawful, or unconstitutional. And thirdly, attempts to injunct Parliament are inimical to the desired levels of institutional comity and cordial relations among the branches of government. Intergovernmental relations survive on interinstitutional respect and difference in a mutual manner on the basis of reciprocity. Parliament ought to respect the judiciary, and the opposite is also true. Now, honorable senators, ladies and gentlemen, the Supreme Court and the petition number 32 of 2014, that is Justice Erick Mutai and another versus Martin Nyaga Wambora and another, 2017, also had an occasion to consider the competing constitutional imperatives and Articles 1 and 2 of the Constitution in what will be described in legal parlance as the locus classicus on this particular matter. In this matter, therefore, the Senate had resolved to remove the then governor of Embu County, Governor Martin Wambora, from office by impeachment. Additionally, the High Court had issued conservatory orders, the effect of which were to prevent the impeachment of the governor. Following his impeachment, the governor challenged the impeachment by an application before the High Court and sought interim orders for his reinstatement into office and an order of contempt of court against the appellants, that is the Speaker and Clerk of the County Assembly of Embu, for allowing an impeachment motion to be discussed, passed while a conservatory order was in place. The governor was successful in his application. The court held that all proceedings conducted in disobedience of the court orders were null and void and found the appellants guilty of contempt. Aggrieved by this decision, the appellants filed an appeal at the Court of Appeal challenging the findings of the High Court. The Court of Appeal affirmed the findings of the High Court, leading to the appeal to the Supreme Court. Before the Supreme Court, the appellants asked that the trial court ought to have noted the legitimate dilemma facing the Speaker of the County Assembly, who was subject to constitutional timelines, yet was faced with a court order stopping the process. It was urged and argued that in this case, that the Speaker had complied with the Constitution in the context in which the question of constitutional obligation on the one hand and the burden of knowledge of the court order on the other were at stake, and asked the court to clarify to what extent parties would be in violation of legal requirements if court orders that conflicted with constitutional deadlines were binding on them. In rendering its decision, the Supreme Court made reference to the decision of the Court of Appeal in the case of Mumo Matemo versus Trusted Society of Human Rights Alliance and two others, Civil Appeal number 290 of 2012, where the Court of Appeal adopted the High Court's position on the doctrine of separation of powers to this effect. I quote, must mean separation of powers, must mean that the courts must show a difference to the independence of the legislature as an important institution in the maintenance of our constitutional democracy, as well as accord the executive sufficient latitude to implement legislative intent. Yet, as the respondent also concede, the courts have an interruptive role, including the last word in determining the constitutionality of all government actions. The Supreme Court further made reference to its decision in the Speaker of the Senate and another versus Attorney General and four others, reference number 2 of 2013, and noted that the court had cautioned against interference with running processes in other arms of government, and had this to say, and I quote, that may occur in either of the houses of parliament. The court cannot supervise the workings of parliament. The institutional committee between the three arms of government must not be endangered and warrantment of the other. The Supreme Court aptly summarized the principle applicable to separation of powers in Kenya context as follows: that each arm of government has an obligation to recognize the independence of other arms of government. Two, each arm of government is under duty to refrain from directing another arm on how to exercise its mandate. Three, the courts are the proper judge of compliance with constitutional edict. For all public agencies, but in exercising for the due functioning of constitutional governance, the courts are to be guided by restraint, limiting themselves to intervention in requisite instances upon appreciating the prevailing circumstances and the objective needs and public interests attending to each case. And lastly, in the performance of the respective functions, every arm of government is subject to the law. In the end, the Supreme Court upheld the conservatory orders that had been issued in this matter. In a more recent Court of Appeal case, that is civil application number E093 of 2023, the Honorable Kawira Mwangaza versus County Assembly of Meru and others, the Court of Appeal also considered the issue of whether a court has jurisdiction to intervene in an impeachment process that is provided for in the Constitution and which has strict timelines for determination. In its ruling, delivered on the 27th of October 2023, the Court of Appeal, while relying on the decision of the Supreme Court in the Embu impeachment matter, held as follows: that the courts cannot, in the first instance, intervene in the impeachment of the applicant. This is because of the strict timelines provided by the law. The Supreme Court decision of Justice Kariuki matter is binding on this court. The preliminary objection is therefore upheld. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. Now, honorable senators, ladies and gentlemen, I note that the constitutional mandate to impeach a governor is assigned to the County Assembly and the Senate. Article 181 of the Constitution provides the circumstances under which a governor may be removed from office. In line with the terms of Article 181(2) of the Constitution, Parliament duly enacted the County Governments Act, Cap 265, which at Section 33 sets out the procedure to be followed in the proceedings for the proposed removal of a governor. Further, Standing Order 8 of the Senate Standing Orders also provides for the procedure for removal of a governor from office. These provisions provide for strict timelines to be followed by the Senate in such proceedings. Honorable Senators, constitutional and statutory timelines cannot over ex parte orders, as this will jeopardize the Senate's constitutional and statutory obligations. Professor Kithure Kindiki, the then Deputy Speaker in the Senate, could not have put it in a better way in a ruling that he delivered on the 23rd of October 2019, when he ruled, and I quote, are respectively but firmly determined that beyond peradventure, courts of law cannot and shall not stop or neither I rule any injunction interfering with the work of Parliament has no effect on Parliament in exercise of its constitutional functions. Such court orders have no effect on the National Assembly or the Senate or any of their committees, respectively. In the unlikely event of any such orders, Parliament and its committees shall proceed unabated, unfettered, and unhindered, as may be directed by the respective Speaker of Parliament. Now, the question of the effect, if any, of the court orders injuncting the Senate from conducting any business is well settled. In this respect, the determination on the question is the same regardless of the position advanced by the County Assembly. Whether or not there was, in fact, a court order in this matter does not matter. Nothing turns on it. The result is the same, which is that Parliament cannot be prevented from the discharge of its constitutional functions by dint of an order of the court. The second issue then is the second issue for determination then is whether, as contended by the governor, the threshold of 2/3 required at the County Assembly was not met. Related to this question is whether this is a question of fact, necessitating evidence to be adduced by the county, as contended by the County Assembly, or a pure question of law requiring to be determined before the proceedings can continue. In other words, is this a classical preliminary objection or not? This question is important because in virtually all impeachment proceedings before the Senate, preliminary objections have been raised, and in no instance has the Senate terminated proceedings on the basis of a preliminary objection. Successive speakers have ruled that a preliminary objection would be considered together with the evidence and determined on the merits of the matter. In truth, the findings have meant that the preliminary objections raised did not fit within the true character of a preliminary objection. Now, a preliminary objection was defined in the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA 696 as follows. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and which is argued as a preliminary point, and which, if argued as a preliminary point, may dispose of the suit. A preliminary objection raises a pure point of law, which is argued on assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has not been ascertained, or if what is sought is the exercise of a judicial discretion. In this case, it is not in contention that the County Assembly of Kericho has 47 members, and that one of these members voted in favor of the motion for the proposed removal from office by impeachment of the governor of Kericho County. The only question that has arisen as a preliminary matter is whether the 2/3 threshold was met, and the consequence if such threshold was not met. Linked to this question, it is the question whether this is a matter to be determined by the Speaker under Rule 30 of Part 1 of the third schedule to the Senate Standing Orders, or a matter to be determined by plenary. This matter was argued by counsel for the governor in support over determination by the Speaker, while the County Assembly took the opposite view. Senators who spoke supported the view advanced by the County Assembly. It is not in doubt that the trial court in impeachment matters is the Senate. It is, however, also not in doubt that Rule 30 vests in the Speaker as the presiding officer the power to make certain determination for purpose of continuity of proceedings, of impeachment proceedings. Nevertheless, taking one thing with another, and in the context of the totality of the current proceedings, I rule that the question on whether to uphold the preliminary objection raised by the counsel for the governor on the matter of whether the threshold for impeachment was met will be determined in the present case by a vote of the Senate. This is so because, as earlier explained in this ruling, the preliminary objection raised in the present case is of such momentous character that it goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. The County Governments Act and the Senate Standing Orders did not contemplate a situation where the Speaker is called upon to terminate the proceedings in a proposed impeachment without the participation in that decision by the Senate. I further rule that considering that the effect of this vote could be a determination of the impeachment process as a whole, this is a matter concerning counties. And accordingly, the preliminary objection will be upheld if supported by 24 delegations. In such event, the present proceedings will forthwith terminate. The procedure for going to this vote, honorable senators, will be by motion in the usual manner, preceded by a notice of motion. The vote will be taken upon the conclusion of debate in the usual manner, and to this end, I have directed the clerk to prepare and circulate a supplementary order paper containing the notice of motion and the motion as soon as I conclude with this ruling. One further matter from the preliminary issues raised remains outstanding, which is the matter of the request made by the County Assembly for the protection of the witness. This question will only become relevant after the disposal of the motion. It is so directed. Thank you. Clerk, kindly circulate the supplementary order paper so that we get down to business.